Hi, welcome back to the HOA Hell podcast. I'm your host, Michael Kushner. With me today is Senior Associate from MBK Chapman, Sam Kill. Sam, good morning.
Hello, Mike. How are you?
I'm fine. Thank you very much for being here again.
Appreciate that. Good to be with you.
Today, we're going to talk about a trend that we're seeing more and more. It's been going on for a few years, but I feel like it's becoming more common. And we're going to use two very recent examples. I'm going to be showing on screen a letter, redacted of course, from one of the most well-known HOA-side law firms in California. And I'm going to be discussing another letter. I'm not going to show the other letter for interest of time and because so much of it would have had to have been redacted that it was just difficult to use. And so it was easier just to talk about it. Another HOA-side, very, very well-known law firm. And there's about 10 of them in the state. These are two of the most well-known of that 10. And both of them had one thing in common, which is the topic today. And that is how HOA-side attorneys are using harassment and certain labor laws as a weapon. They're weaponizing those concepts to silence preemptively homeowners who are objecting or questioning actions by the board.
Absolutely.
And yeah,
unfortunately, that's becoming more and more common, and we keep seeing it both with actual clients and consultations we do.
Right. And I think, personally, that what we're going to discuss today, if it's happening to homeowners in your association, it should alarm you because it could happen to you. And it is a complete bastardization of the law, and it's intentional, in my opinion, at least in the case of the letter I'm going to show you on screen. I happen to know it was intentional. And what I mean by that is the lawyer said the things he or she said, knowing that what he or she was saying was not a genuine statement of how the law works. But it is surely a powerful means of cowing a population. And that's unethical. So let's talk about this new control tactic. Okay? HOA law firms have started using the word harassment to describe conduct that clearly doesn't fall within the statutory definition of harassment. And they're not using it colloquially. They're using that term legally, which is where I have a problem with it. And when you are trying to hold your board accountable and you intercede in a way that is protected by not only the Davis-Sterling Act, by the California Constitution and the U.S. Constitution, it is disturbing when lawyers working for HOAs actively interfere, okay? Because that's not how it's supposed to work.
Yeah.
Okay. So we're seeing this surge of these cease-and-desist type letters. Threats of fines, threats of suspension of privileges, and even calls for revocation of communication rights, okay? All based on vague and invented claims of harassment or creating this part's great, creating a uncomfortable workplace environment, which is, for reasons we'll discuss, completely insane. Now, sometimes these cease and desist letters come because somebody is taking photographs or video of HOA board members or vendors while they are in the common area or while they are on the particular homeowner's exclusive use common area or private property. In other words, for people taking videos or photographs where they're allowed to take videos or photographs.
And engaged in conduct that refers to the member's interests in the common areas or the association.
Even if it didn't, it wouldn't matter.
Right.
Okay. Even if it didn't, it wouldn't matter.
Right.
You are allowed to take video and photographs of anything that you can see from public or from a place you have a right to be, other than directing into somebody's private property through a window, through an open door, that sort of thing. You can't stand on the sidewalk and film inside somebody's home. But you can stand on the sidewalk and film anything else you want if the sidewalk is common area or public property, either way. Okay? Sometimes it's for videos and photos. Sometimes it's for confronting vendors or questioning vendors. The landscaper's in the middle of chopping a tree into smithereens. And a homeowner goes up and says, wait, what are you doing? Why are you doing that? Or that's my tree. Why are you cutting my tree? Okay. Confronting vendors, or for sending too many emails.
Right.
Okay. Or for showing up to a board meeting and speaking during open forum and saying things that are considered rude or unfair or disparaging to a board member or another homeowner. So how do we get there? Well, let's start with a letter that we just received in May of this year, so just a couple months ago. Wait, are we? Yeah, last month.
Yeah.
Sorry, last month. So we received it in May, and from a person ended up retaining the firm. And I'm going to read through this letter real quick. I just want to read what was written by the lawyer. I'm going to let you see it for yourself, okay? And then we'll talk about your conduct towards association staff is clearly disruptive and a nuisance to its residents and staff. There's no justification for the board to tolerate your behavior towards staff, which is hostile, threatening, and intimidating. And it goes on. In addition to the above, and it cites CCP 527.6, which is the harassment statute. And it defines harassment. But he's not quoting, not yet. He's saying it's an unreasonable nuisance in violation of that statute. And a claim for nuisance is established by, and then he starts to talk about nuisance. But notice how he doesn't actually quote from the statute that he cited, because had he done that, it would have been obvious to anybody that it didn't actually apply. We'll talk about that. And then he goes and he talks about how this person is violating the hostile free workplace as set forth in a case like Lyle v. Warner Brothers. Okay, so let's now discuss what's going on with this letter in particular. So in this letter, the homeowner was accused of harassment because she recorded vendors who were violating the CC&Rs. Okay, in this particular HOA, they have different sorts of parking. One of the places they have, and these are very, very high-end condominiums. I think the condos start at $1.2 million and go up from there. Okay, and they have some luxury indoor parking, and the CC&Rs are crystal clear. They state specifically that only residents or members, so if somebody was ever renting or living there, can park in that particular structure. Vendors, contractors, and agents of the HOA or guests cannot ever park there. There is separate parking located elsewhere on the property for that. And these vendors were parking in that particular garage and taking up spaces that were set aside for residents. Oh, I think I'm incorrect. Guests were permitted if they were registered.
Oh, okay.
Okay, in advance. I apologize for that. And it was taking up these spots. And so she confronted them and said, you guys have to stop parking here. You can't. And they ignored her. So she began taking pictures of the landscape truck or of the locksmith or whoever was there on behest of the board, parking in that very space. Now, you would think that when she pointed out that it was a clear violation of the CC&Rs, it was right in there, that the HOA would go, you're correct, our apologies, we'll instruct our people not to park there. But no, instead, they said, well, we give them permission. Well, with all due respect to management company or the board, CC&Rs say they can't park there, meaning the HOA can't override that and give permission. It's not how it works. CC&Rs trump, period. End of story. Now, nowhere in the letter did that lawyer mention that our client was assaulting anybody, didn't provide any facts which would demonstrate any kind of assault, provided no facts whatsoever that would actually justify the legal definition of harassment, which we'll talk about later in this show. They cited the harassment statute, didn't quote from it. And again, when we look at that statute very clearly later, you'll see why. And then they talked about how it was a nuisance, but they relied on it being a nuisance because it was legal harassment. Well, the premise fails. It wasn't legal harassment, and therefore could never have been a nuisance. She was acting well within her rights, this homeowner. Okay? This is just a resident documenting very clear, unadulterated misconduct on the part of agents of the board, these vendors. Now, you have this big, scary law firm send this 6-page letter. I only read you a portion of it, threatening to sue our client for labor violations and for other business torts without a slightest justification. What are your thoughts on how just egregious that is?
Well, it absolutely is, and
am I making this up?
I routinely push back on this, and you're not making this up. I mean, it's been progressively on the rise in terms of the frequency of how frequently we see these. And the other thought is, it's a lot to unpack. I mean, it's not just a singular thing that they're alleging without substantiating it or providing any evidence to that effect or any facts, right? I mean, you mentioned assault, but no facts to evidence any assault. And then it almost seems it's either lazy and they're just using a template-based correspondence to just kind of put everything in there without really actually discerning what actually occurred in the underlying events, or it's, there's some kind of a malice there, perhaps. They're doing intentionally, and that is what you alluded to basically, discourage folks from asserting their rights or engaging in protected legitimate speech.
This was a person. Remember what the purpose of all this videotaping and taking pictures was, and confronting them was, you guys are violating our governing documents and you just stop. That was the purpose.
It's very clear. Proper purpose, legitimate, holding the board to account, or at least bringing that to their attention in case they were unaware of it. And guess what? Rather than them acknowledging it and playing fair and in good faith.
And saying, you know what? You're right. We're going to tell them to park in the guest parking. Because there's ample guest parking.
Right.
Ample.
Agreed. Yeah.
And not far away. Just located outside that specific garage. But when you have, if it were the rules and regulations and the board wanted to change them to allow their invitees to park inside there, then they could have done it the right way with a 28-day notice and hold the meeting and blah, 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 blah. They could have done that, no problem. But this was CC&Rs. If they don't like it, amend the CC&Rs by getting the proper vote, or abide by the CC&Rs. And who has the duty? Other than homeowners, they have to abide by the CC&Rs. Who else has to abide?
The board.
The board.
And by extension, it's agents, because
it's
they
agents,
work at their behest.
And that's the thing here, that this attorney, and I say intentionally, misstated the law surrounding what harassment is, and they did it for the sole purpose of cowing or preemptively scaring this person into submission so that this person would stop in their efforts to hold this board accountable. And I mentioned when you were looking at the letter itself, they even cited a case that when I talk about this later, had zero application to the present situation. So either this lawyer cited a case and never looked at the case, even the head note would have told this person it doesn't apply, or he did it on purpose. And I'm going to say he did it on purpose. And I guess it was a he. I was trying, I was going to say he or she, but I forgot. So it was a he.
Just don't give him any initials.
No names.
Yeah.
Okay. So this has nothing to do with, from the board's perspective, safety or enforcement. This is pure intimidation and exercise of power. And that's what we're here to expose, is the abuse of that. Okay. Now, the second letter, this one came this month from another very, very well-known HOA-side law firm in the state of California. Here are the facts. Some HOA vendors were doing work in a members exclusive use common area. They had not been there before doing the same kind of work. This wasn't like it was done every Tuesday or every quarter or whatever it is. This was just, they appeared one day. And this is her exclusive use common area, meaning that it's for all intents and purposes her private property, except that she doesn't own it. But she happened to have maintenance responsibilities for it, but repair and replace responsibilities were, or I guess replace responsibilities were in the HOA, but maintenance was her duty. But these vendors are in there, okay? So of course she confronts them, like any sane person would. Now, and it wasn't the norm, and so she didn't understand what was going on. So at first it was, I need information. What are you doing here? Who are you?
Right.
Okay? So according to the HOA's law firm, in this another 4 or 5 page letter, she demanded to know who they were. She demanded their names so that she could put their names down in a letter or email to the HOA when she was going to complain about what was going on and report. She wanted to know who she was talking to. And instead of just, I'm John and I'm the foreman of ABC Landscape and whatever it was. They refused to speak to her. So, of course, she followed them out to their truck, take pictures and get information. So she was taking pictures of them. Again, while they were on her exclusive use common area or in the common area, which she has a legal right to do. And she did start to yell at them when they weren't being cooperative. She was screaming, and she might have cussed at them. I believe she did. She says she doesn't remember if she used profanity, but let's say she did. Let's say she did for the sake of argument. Now, let's be clear. We don't encourage homeowners to be profane or rude, especially to the vendor directly, where the vendor's just doing what the vendor's told to do by people that hired them, which is the HOA. You know, it's like killing the messenger, okay? So we don't encourage that. One of our mantras, and we've talked about this in several prior episodes, is in all communications, especially those in writing or that are being recorded, in all communications, be professional, be unemotional. You want to look like the reasonable party. Well, cussing and screaming at somebody isn't the way to do that. Now, people lose their temper, people get angry, and that's understandable, and I get it. And we're not necessarily, you know, and we would tell this person that. In fact, we did tell this person, you shouldn't have done that. But that doesn't take away from the larger picture here, which is everything she was doing, including the cussing in the way it was described in the letter, because she doesn't remember whether she used that kind of profanity. But taking the author of the letter's word for it, even everything they said that she did didn't rise to the level of harassment. And this law firm accused her of the same thing. Harassment. They didn't cite the statute. They just said it was illegal harassment and they were going to get a restraining order against her. Good luck with that. We'll talk about that. And they also didn't cite the case, but they brought in how it was interfering with the their employment obligations by providing a hostile-free workplace for these vendors. Again, a complete misstatement of the law. But nowhere in there did they say the police were called. But yet they accused her not only of harassment, but of assault, actual legal assault. Now, in one of the later episodes of our 6-part series on neighbor disputes, I don't remember which episode, it was 4, 5, or 6, but in that episode, we specifically talked about the legal definition of assault and battery. This didn't come close to assault, not even in the same universe. Using the lawyer's description of what occurred and taking it at face value, it didn't constitute assault or come anywhere near it. I'm not even saying, you know, what the lawyer described would have been assault, but the lawyer's lying. I'm saying, let's take the lawyer at his word. It wasn't assault. That's how egregious it was. Okay? So they threatened to get a restraining order. They threatened to sue her for tortious interference with contract. It's a business tort. Okay? So let's stop there. HOAs don't have employees in the same sense when they're using independent contractor vendors, which they always do. These are not employees in the same sense that a private company has employees.
The vast majority do not.
Independent contractors, like the landscapers or the people that do the roads, you know, if it's a private thing, or the electricians or whatever, the contractors. These are independent contractors under the law. They are not employees. They're not protected under the same workplace harassment laws that exist for regular employees. And saying the contrary or arguing the contrary is an intentional distortion of the law. Either intentional distortion or a gross misunderstanding on the part of the lawyer. And I'm not sure which is worse, if I'm being honest. Okay? So what does California law actually say? Well, we know assault. You talked about it before in that episode. Give us a quick refresher on what assault is. Real quick.
Well, basically, an intentional act that causes an apprehension of an imminent, harmful, or offensive contact. By the recipient or percipient.
Right, exactly. That's exactly right.
So it has to be an overt act. You know, I'm threatening to basically essentially engage in what would constitute a battery, an offensive touching, contact, harmful, and offensive. But it really can't be where you're remote or, you know, you're just taking a photo. I mean, that does not rise to an assault.
And none of the facts here is, as set forth in this letter, constituted anywhere near assault. Okay? Now, let's stop and ask the one question. What does California actually say about harassment? Well, let's take a look, okay? The statute for harassment in California is Code of Civil Procedure, Section 527.6. And if you look at your screen, you'll see that code section.
Mm-hmm.
Okay? Unlawful violence, a credible threat of violence, or a knowing and willful course of conduct
Right.
directed at a specific individual or individuals that seriously alarms, annoys, or harasses, and, this is important, folks, serves no legitimate purpose.
Mm-hmm.
The course of conduct must be that which would cause a reasonable person to suffer substantial emotional distress and must actually cause substantial emotional distress.
Mm-hmm.
That is what we're talking about, folks.
Right.
Okay? Nothing described in that letter did that.
No.
Nothing.
That's a pretty heightened standard.
It's
And
for good reason.
and none of those facts, based on the attorney's wording, rose to that level.
So let's be clear, okay? To qualify as civil harassment within the meaning of the very statute that first firm cited to by name, and this one just obliquely referred to in the second case, there has to be either unlawful violence or a credible threat of violence or a knowing and willful course of conduct.
Right.
That means one instance isn't going to cut it.
No. A
Okay?
pattern or recurring.
And that course of conduct has to seriously alarm, annoy, or harass a person. It can't have any legitimate purpose. And then the statute goes on to define, and by the way, here's what we mean when we talk about seriously alarm or annoy or harass. It has to cause reasonably a reasonable person to have either suffered emotional distress or would suffer emotional distress. Okay? Substantial amount of emotional distress. That is a very high standard.
Right.
And in both cases we discussed, it didn't even, the conduct described by the lawyers on the HOA side didn't even come remotely close to qualifying in either way.
Well, in other words, it has to be extreme and outrageous to cause that kind of a reasonable and emotional distress.
And remember, reasonable.
Yeah.
If you happen to be a very sensitive landscaper, okay, and you've had years of abuse at home, and then now you like to, trees make you feel happy and peaceful, and then somebody yells at you and you crawl into a shell and you cry, that doesn't cut it because that's not a reasonable person standard. Okay, the eggshell defense doesn't work here.
Yeah.
Okay, so let's be clear. Taking pictures and video where you're allowed to take pictures of video, i.e. common area or your place, your property, doesn't qualify as harassment. End of story.
Yep.
Okay, I don't care if somebody hates being videotaped. You don't have an expectation of privacy. If you don't want to be videotaped or photographed when you're out in public, that's the common area, then stay home and never leave. That's what the law says, folks. Sorry if you don't like that, but that's the law. And I shouldn't say sorry if you don't like that. Sorry if the HOA lawyers don't like that. That's the law.
Right.
Okay? Asking questions to HOA vendors, especially as those questions relate to something related to your rights. Okay?
Lawful and legitimate.
Lawful and legitimate. That does not constitute harassment. Okay? Objecting to what an HOA or a vendor is doing does not constitute harassment. Sending emails up to a point does not constitute harassment. I say up to a point because there is a point where it could become harassment. Could. But that's a high measure. We're talking dozens and dozens of emails per hour, let's say, or text messages where you're lighting them up 50, 100 times a day. That could be harassment. They didn't allege that here. There was a few emails, 3 to 4, over a period of a week. It's not harassment. Just because they don't want to receive them or hear from her doesn't make it harassment. Sorry. And showing up at meetings and taking your 2 minutes or 3 minutes or whatever you're given an open forum to lambast the board and accuse them of wrongdoing or even embezzlement or even crimes is not harassment. It's protected speech. Okay? If all you're doing that is deemed harassing is criticizing, it's not harassment. Now, if you're going over your allotted time, they give everybody 3 minutes. Courts have held 2 or 3 minutes is reasonable during those open forums, and you refuse to step down off the podium, okay, that could be. Now we're talking. They have the right to remove you. If you refuse to be removed and you breach the peace, now maybe we're getting in harassment. But again, the lawyer didn't allege any of this happening, okay? So these law firms did this And they did it, in my opinion, knowingly, but it would be almost as bad as if they did it negligently. And they did this for one reason, to scare these people into submission.
Yep.
And the two people, instead of being scared into submission, hired us. Okay? Now, I'll be blunt. Let's talk about the workplace scenario. A few minutes ago, we talked about how the fact that independent contractors, who these are not subject to the same laws that protect employees.
Right.
And that's true. But in that first letter I actually showed you earlier in the show, the lawyer cited a case called Lyle v. Warner Brothers. If you look at the Lyle v. Warner Brothers case, and you can Google it yourself, put that name in, and take a look at the case yourself. It relates, it's an employee who was subjected to repeated sexual harassment, okay, by coworkers.
Yeah.
It's not in the same universe. Forget the ballpark. It's not in the same universe as to what happened here. Number one, as HOAs will continuously remind homeowners, we, the HOA, the board, are in contract, privity of contract with our vendors. They don't work for you, they work for us. So at best, if you wanted to buy into the lawyer's theory, and it would still be wrong because they're really independent contractors, but let's say you wanted to buy into the lawyer's theory, an argument would be made in the lawyer's mind that the board might be employers, but a homeowner who, by admission, these people don't work for and have no privity of contract with, are not employers. They are not agents of the HOA. They are private individual members of the HOA. They are just citizens. They are nothing else. They in no way can they be deemed unemployed within the meaning of the Lyle v. Warner Brothers case. They are not co-workers, and they can't be guilty of torts that would otherwise be committed by a co-worker. It doesn't apply. It just doesn't apply. And the lawyer knew it. Okay? Harassment-free workplace environments are guaranteed to employees. They aren't guaranteed to independent contractors anyway, even if the homeowner was an agent of the board.
Right.
The remedy for the independent contractor in such a case would be to quit and then sue for contractual damages. You have to pay me the rest of the fee that you had agreed to pay me. I left because you forced me out. Now, the HOA there are remedies the HOA could pursue against the homeowner for that, but they don't fall within harassment or workplace labor claims, workplace-related labor claims and harassment claims. They lie in business tort area of the law.
Contractual, yeah.
Okay? And that's not what these letters talked about. Had they said in that letter, if you continue to do this and we lose this contract, we're going to go ahead and sue you for interfering with that contract, that would have been one thing. And then it just would have been a he said, she said, and we could have addressed in court whether the claim was, whether they could prove the elements of the claim, but the claim would have been appropriate. But to couch it in terms of harassment under 527.6, or to couch it in terms of workplace harassment and cite a sexual harassment case is just inane.
They're conflating it. Yeah.
It's just dumb. Okay? Threatening homeowner with litigation, threatening a homeowner with losing their right to communicate with management company or the board is utterly inappropriate in almost every single case, period. As long as you live there, you have a right to air your grievances to the people who are the stewards of your money and who have fiduciary duties to you. And they so cavalierly throw out in these letters, here are all the things that are going to happen to you. We're going to get a restraining order. We're going to sue you. You're not going to be able to communicate. It's all wrong. They can't do that. It's abusive. What do you think?
Agreed. No, that last one is really egregious to me. I mean, yeah, you can make a bunch of baseless. Well, you shouldn't, but they do, unfortunately, routinely. But that last one, to curtail someone's speech, legitimate speech, it's
pathetic.
They're still expected to pay their dues and do their part, but they can't communicate on legitimate purpose.
Well, more than that, talk about hypocrisy.
Yeah.
You have to abide by the governing documents, and if you don't, we're going to bring you up on a hearing. We're going to fine you, and we're going to take away your privileges. We, however, can choose to cavalierly ignore the governing documents because we want to do so. We want to allow these vendors to park where they're not supposed to park under the very, very plain English, plain language CC&Rs. It said only residents and their guests that are registered.
And by the way, most of these letters, they are transmitted or delivered without any due process.
Well, they come right from the lawyer.
One-sided, yeah. Right from the lawyer.
Now, as long as the letters don't actually, it would be illegal because there would have to be a hearing.
Yeah.
As long as the letters aren't accompanied by, and you're now we're going to put you on a hearing at this date. Here's the problem, though. The letter alone is bad enough. That's the sin, in my opinion. Forget that. Yeah, these letters weren't accompanied by, and by the way, you have a hearing set for this date. I don't care. The fact is, they were threatening these homeowners. And remember, let's not forget, the purpose of the threat was to shut them up. Stop trying. Stop making waves. Stop rocking the boat. We're going to let people park here, and we don't care that it's against the rules. We want you to shut up about it.
Right.
That's not how it works.
Yeah.
I'm sorry. HOA wrong. Lawyer stupid and wrong. Period. My opinion, lawyer is a slime ball. Both of them. Slime balls. Okay? Those particular ones that wrote those letters are slime. Because what they did was actually illegal. You were under the rules of professional conduct. A lawyer is not supposed to completely and utterly misstate the law to gain an advantage. You cannot make stuff up. We're officers of the court. You can't do it. If they knew about it, they're guilty of that. If they didn't, they're guilty of malpractice. So pick. Okay? I choose to think that they did it intentionally, that they're smarter than that, because any moron that looks at the Lyle case would know it didn't apply. So, how do you push back? This happens to you, and you don't happen to have our number on speed dial. Okay? How do you push back? Well, look us up and call us at MBK Chapman. That's one way.
Yeah.
Another is handle the issue for yourself. So let's assume that's the direction you want to go. What do you want to do? Well, you get this letter. Once you calm down enough to write back unemotionally and intelligently, you craft a response. And if I were you, I would craft the response in a way that addresses. I would quote any portion of this person's letter that deserved a response or pushback. And I would quote and say, here's what you said, and here's my response. Maybe even a different color, okay? I call that interlineation responses. It's the best way to make sure you don't miss anything. But respond in detail. Every conclusion they've reached, every fact that they've stated, if the fact is untrue, if it's not a fact, tell them that they're wrong and explain what the real fact was, and then challenge the premise and the conclusion, okay? Cite, for example, in the case of the first firm where I showed you the letter, this person came to us, but had they done this on their own, they should have cited the specific CC&R section that took the ability of the HOA to make a decision to allow contractors to park there, and said it took it away from them. The CC&Rs are very clear. Only residents and guests who have been registered with management can park in these spots. These contractors don't fit into either of those categories, and without an amendment to these CC&Rs, they can't park there. And the HOA can't bend the rule, ignore the rule. They can't do that. It's not how it works. You need to talk to your client and make sure they're complying with the governing documents, just like you're telling me that I have to comply with the governing documents. And then I would push back if you have the wherewithal to look up the definition of harassment, and they cited the statute in that first letter, look it up and go, I'm looking at this, and it's best, I'm not a lawyer like you, but as best as I could tell, you're making things up because there was no this, or this, okay? So how can you claim? In other words, meet every accusation, factual or conclusion, that they lob at you, respond back, point by point, calmly, unemotionally, professionally. Let that lawyer come off as unreasonable and unhinged. And it was an unreasonable letter, and in my opinion, an unhinged letter, because it was basically screaming and shouting and yelling you could almost see the fervent hope in the letter that it would be enough to shut them up, because they got challenged and they backed down very quickly. Why this matters? It's not just about HOA overreach. If the HOA is allowed to do this, and enough people are cowed and silenced, then the HOA will now be incentivized and empowered to really go rogue and do what we've seen lots of HOAs do. Mismanage the money and use these HOAs and the power of these HOAs, especially one that had this much money, okay, use it as their own little fiefdoms.
Unfettered and unchecked, yeah.
And you can't allow that.
No.
You can't allow that. You've got to make sure that you are always asking questions and that you're always holding your HOA accountable. And if you're going to remember anything about this episode, I want you to remember this one little tidbit. This is a little gem you can take with you. If everything is harassment, then nothing is harassment.
Mm-hmm.
And when you reach that point, the people who truly have been harassed, who clearly have what's happened meets the definition.
Right.
It degrades the power of that word
Mm-hmm.
when it's so cavalierly misused and intentionally misused.
Mm-hmm. Agreed.
If everything's harassment,
It dilutes it.
then
yeah.
nothing is
Mm-hmm.
harassment. And the real victims are going to be the homeowners. So if you received a letter like this in the past or you receive one in the future, I'd like to hear from you at MBK Chapman. Send it to us, redact it if you'd like. Or if you've already addressed it and you don't need to hire us, but you have an example of this, I'd love you to send us the letter. We might use it in a future episode. Mm-hmm. We'll protect any confidentialities that have to be protected. Like we did today, we didn't mention names. But remember, just because a lawyer, and in this case, HOA-side lawyer, puts something in writing to you and it sounds really official and pompously legal, doesn't mean it's accurate or correct or that the lawyer has a brain. Don't make that assumption, okay? Challenge it. Just because somebody tells you that what you did constitutes harassment doesn't mean that what you did was harassment. But if you need us, you call us at MBK Chapman, and I promise we'll set your HOA straight. This has been another episode of HOA Hell. If you like this episode, I'd love you to hit the like button. And if you haven't already subscribed, please do so. If you want to leave a comment or ask any questions, we'd love to hear from you in the comments. Until next time, have a wonderful day.